Okay, so check this out. Bryan Kohberger, his defense could mirror OJ Simpson's. What? Y'all like the video? Make sure you subscribe. Let's jump into this one.
So the Bryan Kohberger trial is set to start in August. He faces 4 counts of first-degree murder and 1 count of burglary and could face the death penalty if convicted. The judge setting rules for the courtroom, including the trial being live-streamed, allowing Kohberger's family to attend, and even if they're testifying, and barring the use of certain words like murderer. Let's bring in Harvard Law professor Emeritus Alan Dershowitz. Alan, thanks so much for joining the program this morning.
Sure.
So I covered this trial, not the trial, but the actual case for about 2 months, and I have a lot of concerns here. Can you talk about the chain of custody when it comes to the crime scene? I feel like that is going to be one thing that the defense is probably going to scrutinize. What do you think?
You think?
Oh, no doubt about that. This is so similar to the OJ Simpson case. Here you have a horrible multiple murder. The only defense is who done it? Is the circumstantial evidence enough? Is the chain of custody broken so that you can challenge some of the evidence, some of the DNA evidence? It's so reminiscent of the OJ Simpson case. The defense theory is not going to be to deny it's a horrible crime. They're going to say there just isn't enough evidence. There's reasonable doubt.
Yeah, who did it?
To connect me to this case. And the chain of custody is going to be a very, very important part of it. And the judge's rulings will determine how much evidence the jury hears. If the jury hears all the evidence, this, like the OJ Simpson case, would be a slam dunk. But if there's doubts about the evidence, doubts about the DNA, doubts about the chain of custody, then the jury will only hear selective evidence, and the defense will be able to argue that the circumstantial evidence still leaves open the possibility of a reasonable doubt. I think that will be the defense. The hardest question will be, does the defendant take the stand? That's different than the OJ Simpson case. Simpson couldn't take the stand because he had such a horrible record of abuse toward his wife. Whereas if this guy can take the stand without opening up the evidentiary door to material that would otherwise not come in, he might very well take the stand and say, no, it just wasn't me. So
Alan,
this is going to be a fascinating case that will remind many people of what happened.
What do you think? You think he's going to actually take the stand?
30 years ago.
You bring up an interesting point, and that's who's going to take the stand. I can't wait to see the witness list. And one of the things that the defense is probably going to be working with is you have one of the witnesses, one of the victims there that said that she saw him, but then she went back to bed and he left the crime scene. It wasn't even reported until later that next day when they found the dead bodies. Do you expect the defense to go after this witness?
Well, they're going to have to be very gentle, obviously. And yet, of course, they're going to have to go after the witness. You have to go after every witness that inculpates a defendant, but you have to go after him in a way that doesn't create a sympathy. Remember, too, that the judge has put the family in the front row of the courthouse, the courtroom, and the jury is going to be looking at the family and looking at the other people and trying to sense their reaction as well. And so the defense has to be very careful as to how they treat witnesses and not put them in a situation where there's sympathy, overt sympathy, more sympathy than necessary to these witnesses. So this is far from a slam dunk. You know, cases look like they're easy when the prosecution presents its evidence. And here we've had a media flow of evidence through programs and other kinds of things. And that's going to be another issue. The defense is challenging leaks. Remember, the judge issued an order saying, no, we can't allow any of this to go on television, and it's gone on television. There will be hearings to determine
It's already out there, though. I got about 30 seconds, though, Alan. One of the other things that I'm sure that the prosecution is going to bring up, that the defense is going to have to respond to, is that he was a student. He was a criminology student. Part of that access gave him access to the crime lab. He's researched cases, and so he was methodical in some case. How do you expect the defense to respond to that?
Well, I think they hope and pray that's the strongest evidence, because that's really circumstantial evidence. If you went after everybody who was a criminology student and who had access to this information, there'd be a lot of innocent people. So that becomes one part of a larger circumstantial case. And they're not going to be able to challenge that. They're going to have to adapt that and say, look, he was somebody who was a criminology student. He was trying to help people. He's not the kind of person who would use his criminology background to hurt innocent people.
All right. We appreciate you, Professor. A legal mind that a lot of people know. Thank you, sir.
Y'all, let me know what you think in the comments. Make sure you like the video, subscribe for more, and I'll catch you guys on